Welcome back, everyone. Let's jump right into today's explainer. We're going to dissect a really fascinating and frankly, absolutely crucial NPPE engineering law question. We'll be zeroing in on liability limits and how they hold up, or don't, when a severe professional error enters the chat. Let's get to it. Here's a quick roadmap of where we're headed. We'll tackle the exam question itself, decode the underlying legal theory, break down the correct answer, uncover the traps hidden in the wrong options, and finally, wrap it all up with the key terminology you need to walk away with. All right, part 1. Let's put you right in the hot seat with the actual scenario. Imagine you're sitting in the exam room, the clock is ticking, and you get hit with this exact problem. It reads, a limitation clause caps liability but is silent on gross negligence. A serious error occurs. Which factor is most critical? Take a second to really process that. We have a contract that clearly puts a ceiling on financial responsibility, but it completely fails to mention what happens in the event of a severe, practically reckless error. And right here is the classic multiple-choice minefield you'll have to navigate. Let's review the options. Is it A, whether gross negligence is a recognized separate legal category in the jurisdiction? B, whether the clause clearly contemplates exclusion for the type of conduct alleged? C, whether the damages exceed insurance limits? Or D, whether the client is a public authority? Moving into part 2. Before we even try to solve this, we need to step back and figure out what the examiner is actually trying to ask here. This question squarely hits the engineering law and contract liability section of the NPPE. Specifically, it's testing your grasp on how contracts operate in the real world, when things don't just go wrong, but go terribly, terribly wrong. What the question designer really wants to measure is your skill in contractual interpretation. That's the analytical ability to determine exactly what a contract's wording actually covers, especially when the standard boilerplate phrasing happens to omit an extreme scenario. They want to see if you know how courts read and enforce an agreement when a massive mistake happens that wasn't explicitly spelled out in the text. So let's dive into part 3, the underlying legal theory. Basically, the rules of the game. When you look at standard contracts, you usually see explicit protections. You've got your standard limitation caps acting like a shield in almost every professional agreement. But the real legal drama happens in the gaps. What happens when there's a dangerous silence regarding gross negligence? Well, in legal theory, courts don't just automatically throw the limitation clause out the window. Instead, they pull out a magnifying glass. They look for the true intent behind the words. They ask, did the parties genuinely intend for this clause to protect the engineer, even if they make a massive, catastrophic mistake? Which brings us to part 4. Let's find the logical solution and analyze the correct answer. The correct answer here is B. The most critical factor is whether the clause clearly contemplates exclusion for the type of conduct alleged. But why is this the right answer? Well, because in contract law, the text is king. Ultimately, courts look to see if the specific wording of a contract was truly intended to cover the exact severe failure that just happened. If the wording is broad enough and it clearly intended to cover any error, no matter how serious, then the limitation holds. The crucial thing is to follow these 3 logical steps when you're faced with these kinds of questions. First, examine the exact wording of the limitation clause. Second, analyze the specific nature of the alleged conduct, which, in our scenario, is a serious error. And third, determine if the clause intentionally covers that specific conduct. It's essentially a matching game between the contract's intent and the real-world mistake. Now for part 5. We need to navigate the minefield and look at the psychological traps hidden in those incorrect options. Let's start with option A, which I like to call the jurisdictional trap. This one tries to bait you into thinking regional definitions are what matter most. It asks if gross negligence is a recognized category in your specific area. But remember, the explicit interpretation of the contract will always supersede broad jurisdictional categories. The contract's specific written intent matters way more than how a regional dictionary defines gross negligence. Option C and D play a very similar trick. They're clever distractors. Option C focuses on whether damages exceed insurance limits. Now, sure, practically speaking, that's highly concerning for any professional. But from a legal interpretation standpoint, insurance limits are entirely external to the contract's actual text. Then there's option D, which falsely assumes public authorities somehow have completely different rules for contract interpretation. Whether your client is a private citizen or a massive government body, the way a judge reads that core liability clause remains exactly the same. Don't fall for those external red herrings. Finally, part 6. Let's pack all this up into your exam toolbox with a quick summary and the key terminology. Here's your terminology cheat sheet, just to make absolutely sure you have the precise legal meaning of these keywords locked in. First up is the limitation clause, which is simply a contract provision capping financial liability. It tells you the absolute maximum amount you might have to pay if things go sideways. Second, gross negligence. This refers to a serious error or a reckless disregard for professional duty. We're talking about a significant leap beyond a simple honest mistake. And lastly, contemplated exclusion. This means determining whether the contract wording was specifically intended by both parties to cover the exact act or failure that just happened. So, to summarize, your absolute biggest takeaway for the exam, and honestly for your entire professional career, is this. Always prioritize the specific intent and wording of the contract over any external factors or broad legal categories. When a serious error occurs, a court's microscope zooms right past the background noise and focuses directly on the exact phrasing of your agreement to determine liability. I'm going to leave you with a final provocative thought to chew on as you continue studying. If you were the one drafting this contract, what specific word or phrase would you add to it tomorrow to ensure your limitation clause protects you even from a serious error? Seriously, think about how you would rewrite that clause to completely bulletproof your own liability. Keep that in mind, keep studying hard, and I'll catch you in the next explainer.